Hi, this is Denise Erasmus from ProMet Source. Today we are going to talk a bit about U.S. law as it applies to web accessibility. We're going to discuss Section 504, Section 508, the Americans with Disability Act, and then an overview of the U.S. court system, and finally we will discuss an example of an accessibility lawsuit. But first, a brief note. We will not be discussing all accessibility laws. If you wish to learn more details about the laws discussed or any others, please visit w3.org/WAI/policies. The Rehabilitation Act of 1973 is legislation that declares rights for individuals with disabilities. Section 504 of the Rehabilitation Act requires federal agencies to provide individuals with disabilities an equal opportunity to participate in programs and access to benefits. Section 504 applies to all federal agencies and those doing business with or receiving funding from the federal government. The Rehabilitation Act was amended by Congress in 1998 to include Section 508. Section 508 was enacted to eliminate barriers in information technology, make available new opportunities, and encourage the development of new technologies. It applies to all federal agencies when they develop, procure, maintain, or use electronic and information technology. The Americans with Disability Act was enacted in 1990 and was the U.S. government's first step towards addressing the needs of citizens living with disabilities. The original ADA was a move to combat discrimination against disabled persons by potential or existing employers, government, and unions. In order to be covered by the ADA, you have to fit these three descriptions. 1. Possess a physical or mental impairment that limits major activities in life in one or more way. 2. Have a record detailing the impairment. 3. Be regarded as currently having the recorded impairment. The American with Disabilities Act is divided into 5 titles or sections. Title I addresses discrimination in the workplace, requires employers to make reasonable accommodations for applicant or employees with disabilities. Titles 2, 3, and 5 apply to state and local government, transportation, public service, and public accommodations. All must have access to physical locations and services. Title 4 applies to telecommunications. State telephone companies must provide a system for the deaf, TDD, or similar. In order to understand the accessibility lawsuit, we're going to discuss it. It is important to have a general understanding of the U.S. court system and how appeals work. The U.S. court system is broken into 2 main sections: courts managed by the state government and courts managed by the federal government. A majority of civil and criminal cases are heard by the states. However, if a case involves violations of the U.S. Constitution, treaties, or federal laws, it is a legal dispute between citizens of different states or foreign citizens, it is a bankruptcy, copyright, patent, or maritime law case, or it is a criminal matter listed in the U.S. Code, it is heard by the federal courts. For federal cases, they are first heard by the U.S. District Courts. An appeal can then be filed to the U.S. Courts of Appeal, and finally, to the U.S. Supreme Court. Now let's take a look at an accessibility lawsuit, Guillermo Robles versus Domino's Pizza, LLC. The case centers around a man named Guillermo Robles who is visually impaired and uses a screen reader to navigate websites. The software reads his computer screen and speaks the information that appears on the websites. Robles used the software to access Domino's website and app. Domino's customers use the website and app to order pizzas. Several times, Robles tried to order a pizza using the website and app. Domino's app and website did not allow for the screen reading software to operate correctly. This meant Robles could not order the pizza. Robles sued Domino's for violation of the ADA. Robles said that Domino's did not make its website and app accessible for people with visual impairments. Robles wanted a permanent order for Domino's to make its website and app accessible. Domino's argued that the ADA did not apply to websites and apps. Domino's also argued that applying the ADA to website and apps violate their fair notice rights. The case was filed in California in September 2016. March 2017, the district judge dismissed the lawsuit, holding that while ADA Title III applies to the Internet, but stating that following the case to proceed without clean web accessibility guidelines from the Department of Justice would violate Domino's due process rights. The plaintiff, Robles, then appealed to the Ninth Circuit Court of Appeals. A unanimous decision was sent down by the Ninth Circuit Court of Appeals stating that the case should proceed. In doing so, the panel held that ADA Title III applies to websites and the lack of official web accessibility regulations does not raise due process concerns. The Ninth Circuit Court of Appeals states it is permitting suits only when there is some connection between the goods or services complained of and an actual physical place. The single prior web accessibility case to come before the Court of Appeals, Cullen v. Netflix 2015, was dismissed since Netflix does not have a physical store. The defendant, Domino's Pizza, LLC, then filed an appeal to the U.S. Supreme Court to have the Ninth Circuit Court of Appeals decision reversed. On October 7, 2019, the U.S. Supreme Court denied Domino's petition, ruling that Guillermo Robles can sue the pizza chain under the American with Disabilities Act. The case is now sent back to the U.S. District Courts to be tried. As this case is one that has certainly received the most attention, we will have to keep watching to see how it develops further and what effect it has on the web accessibility landscape. Thanks and have a great day.